International law and the principle of non-refoulement. International law and the principle of non-refoulement. International law recognizes the principle of non-refoulement as a fundamental norm in the protection of human rights, particularly in the context of refugees and asylum seekers. Key aspects of how international law addresses non-refoulement. 1951 Refugee Convention and 1967 Protocol. The principle of non-refoulement is most explicitly articulated in Article 331 of the 1951 Refugee Convention in its 1967 Protocol. Article 33, 1, states that no contracting state shall expel or return refouler, a refugee in any manner whatever to the frontiers of territories where their life or freedom would be threatened on account of their race, religion, nationality, membership in a particular social group, or political opinion. Customary international law. Non-refoulement is considered a customary norm in international law applicable to all states, regardless of whether they are parties to the Refugee Convention. Customary international law evolves from consistent state practice and the belief that such practices are legally required, opinion juris. The widespread acceptance and adherence to the principle of non-refoulement have led to its recognition as customary law. Universal Declaration of Human Rights, UDHR. While the UDHR does not explicitly mention non-refoulement, its principles such as the right to life, liberty, and security of person Article 3 support the broader concept of preventing the return of individuals to situations where their fundamental rights are at risk. International Covenant on Civil and Political Rights, ICPR. It's torture, cruel, inhuman, or degrading treatment or punishment. The prohibition on non-refoulement is closely connected to this prohibition, as returning individuals to a situation where they face such treatment would violate Article 7. Regional instruments. Non-refoulement is also emphasized in regional human rights instruments such as the European Convention on Human Rights, ECHR, in Europe, the American Convention on Human Rights in the Americas, and the African Charter on Human and People's Rights in Africa. Humanitarian principles that prohibit sending individuals back to situations of persecution, torture, or other serious human rights abuses. International Court of Justice (ICJ) and human rights bodies. Decisions of international and regional courts, as well as opinions of human rights bodies, often affirm and interpret the principle of non-refoulement, contributing to the development and clarification of its application in specific cases. In summary, international law through treaties, customary norms, and regional instruments recognizes and reinforces the principle of non-refoulement as a crucial safeguard for protecting that their actions do not result in the return of individuals to situations where they would face. For any further information about our work and how you could be involved. Video by SLM, Chesquire Legal Media. All rights reserved. Thanks for watching. Please subscribe and share. Video by SLM Chesquire Legal Media. All rights reserved.